Hello and welcome everyone to the next concept class on the basic doctrine of basic structure. All right, so the basic structure doctrine is a judicial innovation, and this is an important part of our discussion in polity in GS paper 2. If you see the basic structure doctrine, primarily this is a debate about five things. There are five debates that it sought to settle. All right, the first debate is with respect to the supremacy of the judiciary and the legislature. The first debate that basic structure doctrine seeks to settle is the debate between the supremacy of the judiciary versus the supremacy of the legislature. All right, the second debate it seeks is between Article 13 versus Article 368. All right, I'll explain to you all these things. Article 13 versus Article 368. Article 13 is the protector of fundamental rights in the Constitution. In one line, it says that a law which violates the fundamental right can be declared by the courts as null and void on the grounds that it violates the Constitution. Article 368, what is Article 368? Article 368 is the power of amendment granted to the Parliament in the Constitution. So this is a debate about first judiciary, supremacy of the judiciary versus supremacy of the legislature. Second, the supremacy of Article 13 versus Article 368 of the Constitution. Thirdly, it is about the supremacy of individual rights versus community rights. All right, the doctrine of basic structure case is about the supremacy of the individual rights versus community rights. Fourthly, it is about the supremacy of fundamental rights versus the directive principles of state policies. And fifthly, it was also a debate about the model of development, the model of economic model that India would follow, capitalism versus socialism. These five things that you must remember about basic structure doctrine is that it's settled for good 5 debates. All right, the supremacy of the judiciary. So we'll see how these debates were addressed. All right, what is the basic structure doctrine? The basic structure doctrine, in simple terms, is a judicial innovation that was enunciated in the Keshavananda Bharti case. It is a judicial innovation that was enunciated in the Keshavananda Bharti case by the Supreme Court, which defines the scope of amendability of the Constitution by the Parliament. According to this doctrine, the Parliament is empowered to amend all parts of the Constitution. According to this, the Parliament is empowered to amend all parts of the Constitution as long as it does not alter the basic structure or basic character of the Constitution. All right, according to this, it says that the Parliament is empowered to amend all parts of the Constitution as long as it does not change the character of the Constitution. So see here, so you will get this handout that is given. There will be a revised handout. There is some mistake there in first point. All right, so you'll get a revised handout and a star mark will be there. If you get this handout with a star mark in near #2, it means it will be a revised document. So here you see that basic structure doctrine was enunciated as a judicial pronouncement. All right, it says that the Constitution is free to amend the entire Constitution as long as it does not alter the basic character of the Constitution. See that the Constitution that was framed and given to us, all right, was created by a Constituent Assembly. It was not created by a Parliament. Therefore, in the early days of our independence, we believed that there are two kinds of powers that the Parliament enjoys. One is the constituent power. One is the constituent power by which it created the Constitution. All right, the constituent power is with the Parliament, which helps it to create the Constitution. And the second type of power that it enjoys is the legislative power by which it enacts laws and legislations. All right, these two functions are performed by the Parliament. One is the constituent power and the other is the legislative power. All right, so in the beginning, earlier times, if you see this entire basic structure doctrine this has evolved because of certain amendments that were brought by the successive governments to pursue socialistic agendas of land reforms or property rights. Right? These were brought as a this judicial innovation came because the government or the parliament enacted certain laws which took away certain fundamental rights, certain individual rights, such as right to property, all right, with a socialistic agenda. All right. So, in a response to this, when citizens, to protect their individual rights, they filed a case in the Supreme Court. This doctrine eventually evolved. So, the primary question that is asked in this doctrine is this answers is can the constitution be amended, and is the parliament's power to amend the constitution unfettered, unchallenged, and without any limitation? So there are four major judgments that we have to know. Very briefly, we will go through these four judgments, and they will be covered in detail in another section, another concept class. So the first case was the Shankari Prasad case. In this case, so all these cases, mostly initial Shankari Prasad sentencing, all these cases, Golaknath cases, it was somewhat related to government socialistic agendas of bringing land reforms, by which it was confiscating the land of big zamindars. Now, right to property is an individual right, all right, a fundamental right. When this was attacked, these zamindars, they would bring the government's the parliament's the parliament's ability to take away such rights. They would bring it into question in a court of law, and these judgments eventually would decide the future course of action and the evolution of the basic structure doctrine. So in the first case, Shankari Prasad case, again, as usual, what had happened is that the government had tried to acquire private property of a zamindar. So the zamindar filed a case, and this question came up. So here in the Shankari Prasad case, you have to remember two things. The first thing is that it's said that there are two powers that this parliament has. One is the constituent function, which means by which it creates the constitution, and the other is the legislative function, by which it enacts laws. All right. In this judgment, Shankari Prasad case, what was said was that the parliament, when it is amending the constitution, the amending the constitution. The amendment amending the constitution is not first amendment to the constitution is not an ordinary law. The amendment to the constitution is not an ordinary law. Therefore, it does not. Therefore, the constitution does not enjoy any protection from amendment under Article 13. I repeat, Article 13 says that if a law of any law that is brought by the parliament or any rule that is brought by the executive, if it violates the fundamental rights, then it can be declared as null and void, as ultra vires of the constitution, against the constitutional values. Therefore, it can be declared null and void by the courts. So therefore, it gave the courts the power to nullify any such acts. But the court in this judgment said that when the constitution is being amended by the parliament, the constitution cannot be protected. Such an amendment cannot be questioned under Article 13, because this amendment is not an ordinary law as defined in Article 13. Therefore, an amendment act brought by the parliament is a constituent function. It is a function that creates the constitution, and it's not a legislative function. And therefore, fundamental rights also can be amended by the Constitutional Amendment Act, and there is no protection available if it is fundamental rights are taken away by a Constitutional Amendment Act. It will not enjoy protection under Article 13. So if you see this, the first judgment, Shankari Prasad judgment, it distinguished between constituent function as well as the legislative function, and it gave supremacy to the parliament. It gave supremacy to the amending power of the parliament, and even it gave a leeway to the parliament to even take away fundamental rights, saying that fundamental rights can be taken away by an amendment of the constitution. And since an amendment act is not an ordinary law under 13, therefore they cannot be declared null and void on grounds of violating the constitution. This is what is there in Shankari Prasad. However, please realize that two major things were happening at this time. One major thing was that the courts and everybody was worried that after independence, there were third world countries in Asia, countries in Africa. We are calling this the third world. In the previous one of the concept classes, we have discussed what is the third world country. The first world represents the liberal democracies of the West, such as United States. The second world refers to the communist countries. And the third world is the newly liberated nations of Asia and Africa. So what was happening was that in all these newly liberated countries, there was a presidential form of government where a president was elected. And what he would do is he would overturn the constitution and he would make changes to the constitution and become a dictator. So there was a big fear in India also that Indian democracy will not survive. Somebody will amend or usurp the constitution and rewrite a constitution. And think of this in our neighborhood also, if you see, there are certain amendments that are made to the constitution by which the basic character of the constitution is altered and somebody becomes a dictator. Dictatorial tendencies arise. In the Indian case also, this concern was very much there. The second concern which everybody had, including the courts that they had, was that during post-independence, there were two models of development. One was the liberal capitalist democratic model of the West, led by United States of America and Europe. The second model of development was a socialist or a Marxist model of development, where the state would have a greater say in how the economy would operate. That would be derived from the second world nations, such as led by USSR. So these two models were there. A big concern was that the government would turn socialist. All right, the government would take socialist steps. Once socialism comes into play, individual liberty is sacrificed in the name of greater community rights. All right, so these two concerns were there. Now let us see how these concerns unfold. In the next case that was there is Sajjan Singh versus the state of Rajasthan. Again, a similar situation had happened. In this question, in this Sajjan Singh versus the state of Rajasthan, it was the Supreme Court upheld the distinction between the constituent power and the legislative power of the parliament. It upheld that there is a difference between the constituent power and the legislative power of the of the Supreme Court, and therefore it said that constitutional amendment acts cannot be reviewed and declared null and void under Article 13. This was upheld. All right, in the second case, we move to the third case, that is the Golaknath versus state of Punjab. Here, the Supreme Court completely turned back its decisions that was it had upheld in the first two cases. Right here, it turned back. It said that there is no difference between the constituent power of the parliament versus the legislative power of the parliament. There is no difference between the constituent power and the legislative power. There is no difference between ordinary law and amendment law. It said an amendment law is also an ordinary law, and therefore it is subject to judicial review under Article 13. Right? Article 13 says, what does Article 13 say? It says that an act that violates or takes away these fundamental rights can be declared null and void or ultra vires of the Constitution, okay, by the Supreme Court. So it said that this amendment acts are having the power of ordinary law itself. It is no different from an ordinary law. All right. Then it says that it's in the Golaknath case, it was held that the fundamental rights cannot be amended, and it was given a sacrosanct position. It says fundamental rights cannot be amended. It was given a sacrosanct position. You cannot take away the fundamental rights. You can amendments by way of amendments. If you try to take away fundamental rights, we are going to do judicial review of the Amendment Act, and these fundamental rights were upheld to be sacrosanct. And here the doctrine of prospective ruling. All right, doctrine of prospective ruling was applied. So Mr. Golaknath, who had filed the case, it was said to him that while you will not benefit from this judgment in the future, and we will not overturn all the previous acts by the government since independence. The minute this ruling was there, it meant that any fundamental rights that had been taken away was not right, and the parliament could not take away the fundamental rights. But the Supreme Court said that already right to property had been or other rights were being hurt, and a lot of legislations had already come that amendments were come which did not come under judicial review because it was held that these amendment acts are not ordinary law and therefore beyond the scope of judicial review. But now in Golaknath case, the courts ruled that these will be coming under doctrine of judicial review, and all amendment acts also can be reviewed by the Supreme Court. However, this judgment, the effect of this judgment will be for future and will not be applicable to the present case or the cases that have already happened before. And the final ruling in this case was the Keshwananda Bharti case, where 13 judges bench, all right, a very large bench, 13 judges bench. So please note two things about the Supreme Court here. The first is that if Supreme Court has made a decision, then that decision can be two things. Yes, the first thing that you need to remember is that there is only one body that is not bound by the orders of the Supreme Court, and that is the Supreme Court itself. If there is one institution in the country that is not bound by the orders of the Supreme Court, it is the Supreme Court itself. All right. Why is this? This is because it allows the Supreme Court to revise its judgments and make corrections if there is an error in the judgment. The second thing is about the Supreme Court rulings is that if a Supreme Court bench has made certain ruling, then that ruling can only be overturned by a larger bench, which means that more judicial minds have been applied. So if Keshwananda Bharti case, 13 judges bench is there, so whatever judgment has come, if it has to be overturned, it has to be overturned by a bigger bench. All right. So in Keshwananda Bharti case, 13 judges bench, it created the basic structure filter. It said that all parts of the constitution can be amended, including fundamental rights. All parts of the constitution can be amended, including fundamental rights, as long as the basic structure of the constitution is not altered. As long as the basic structure of the constitution is not altered. Therefore, fundamental rights can be taken away. But all right, but these will all be subject to judicial review. So it gave power, in a sense, it gave power to the courts to decide constitutionality of amendment acts. All right, and with this, Keshwananda Bharti case is a landmark case. All right, because it said it gave powers to the amending the constitution, powers to the parliament, but more than that, it gave the courts themselves the power to review any action whatsoever of the parliament. All right, it gave so ever any action of the parliament could be reviewed by the Supreme Court. All right, so now what are the features of the constitution that form a basic structure? The first thing is, what features of the constitution can be said to be part of basic structure? So the constitution makers have not enumerated any of the features, or this discussion was not there in the parliamentary debates also, in the Constituent Assembly debates also, as to what constitutes the basic feature or basic structure of the constitution. It is not enunciated by the Constitution or the Constituent Assembly. These are enumerated by the courts. These are enumerated by the courts, and it is an ever evolving list from time to time on the basis of judicial decisions and judicial pronouncements. All right, so this list is not fixed and rigid. Every time Supreme Court comes with a ruling, it can declare a certain feature as a basic feature of the constitution. All right, and therefore, for example, it has already ruled in favor of parliamentary form of government as a basic feature of the constitution. So therefore, an amendment to change the parliamentary form of government would come under judicial scrutiny, supremacy of the constitution, rule of law, judicial review, independence of judiciary, secularism. All these form a part of the basic structure of the constitution. All right, now let's come to the debate on what is the benefits of this judicial, this basic structure doctrine. See, the first thing, the one good thing that is said about this basic structure doctrine is that in one way, while it said the parliament is free to amend any part of the constitution as long as it does not alter the basic structure, it is said that by creating the basic structure filter, it has protected the constitution and the Indian state from collapse. How has it protected the constitution and Indian state from collapse? As we discussed before, that after independence, there was this fear that in these third world countries such as India with heavy population, all right, these countries, largely a very dictatorial leader will come and he is likely to overturn the constitution. He is going to rewrite the constitution, seize power and turn it into a dictatorship or an authoritarian regime. By coming up with the basic structure, this Supreme Court, it is said that it has protected the constitution, or protected the character of the constitution as well as the Indian state from collapse. All right, by ensuring that any attempt by the government to completely override the constitution will not be overlooked by the Supreme Court. So it is said that in early years of independence, it just has protected the Indian constitution from collapse. It has also, as we discussed, that this basic structure doctrine debate is about 5 things: individual rights versus community rights, capitalism versus socialism. So it has also protected, see, these amendments to the constitution that were being made, they were being made and this was being brought into question in the court of law. This was happening because the governments of the day wanted to move to a socialistic form of government. Communism was very popular in those days until the 1990s, before the implosion of the USSR. Communism or was a very popular model of development. Just like liberal democracy, capitalist liberal democracy is a very popular model after the 1990s. All right. So it is said that this basic structure doctrine prevented the constitution from completely taking a left turn or a sharply socialist direction. It may have happened that the successive governments may have gone for a completely socialistic pattern of development. While they did so, but that constitution, it did not reflect in the constitution. The constitution allowed successive governments to take a leftist perspective or a more liberal, follow a path of liberal capitalism. The constitution till even in the 1990s, when you read about liberalization, privatization, global LPG reforms, you will see that the Constitution of India allowed the government of the day to turn towards liberal capitalism as a model of development. This was only possible because of basic structure doctrine was in place. It also, thirdly, it is said that this doctrine has provided a balance between individual rights and community rights. It has provided a balance between individual rights and community rights. All right. It has provided a balance between fundamental rights and DPSP. DPSPs talk about social and economic democracy, giving away, talks about redistribution of wealth, whereas fundamental rights talk about individual rights. So therefore, by this basic structure doctrine, fundamental rights and DPSPs are balanced. It is also provides a balance between capitalism and socialism. You cannot simply alter the constitution and make it a completely socialist state. All right, why? Because the courts can question your laws, saying that this is against individual rights. All right. Then what is the criticism of the basic structure doctrine? The first criticism of the basic structure doctrine is that the basic structure doctrine has no mention in the constitution. Therefore, it is a completely judicial innovation and judicial invention that does not have any parallel in the world. The doctrine of basic structure doctrine does not have any precedent anywhere in the world. It is a judicial invention, and therefore it is alleged that this judicial invention has been created to circumscribe the legislature and the executive. This is to reduce the powers of the legislature and the executive. All right. It is said that it is also once the Supreme Court enunciated the basic structure doctrine. Once the Supreme Court initiated the basic structure doctrine, do you see that it forever has said that the Parliament's any amendment act or any law will come under judicial review? So therefore, do you see that it has bound the Parliament till perpetuity? Forever, it has bound the actions of the Parliament, saying that even if you want to make an amendment in the future, we will bring it into question in a court of law. All right, so it violates. And however, if we see when the Constitution was framed, it was framed with certain rigidities and certain flexibilities. The purpose was to make it a living document. All right, but do you see that this violates just because the doctrine of basic structure, it binds the Parliament, it limits the Parliament, and therefore it violates the doctrine of Constitution being a living document. When the framers of the Constitution framed the Constitution, they provided for powers of amendment to the Parliament, thinking that the Parliament will amend the Constitution on the need basis, on the basis of the changes that may happen in the polity and the society. All right, so it violates to some extent the Constitution as a living document. Also, it is criticized in the legal fraternity that the judges in the Keshwananda Bharti case and in the basic structure doctrine, they decided the ends and then discovered the legal means to achieve them. All right, by which I mean to say is here there was no legal basis of declaring that there are certain parts of the Constitution that form character of the Constitution and changing them would alter the Constitution. There is no legal basis of saying that there are certain aspects of the Constitution changing which would alter the character of the Constitution. So here, technically, what the judiciary has done is that the judiciary has decided that all laws or acts of the Parliament, including constitutional amendment acts, all right, they must come under judicial review. They have decided this first, and then they have come up with legal arguments to justify them. All right, so they have come up with, judges have decided the end judgment that all acts of the Parliament can be reviewed by the judiciary, and they have found legal means or legal justification for them. Then it is said, because of this, it is said that the Indian judiciary became the most powerful judiciary in the world. See, before this judgment, the Parliament was, there was the supremacy of the Parliament. The Parliament could amend the Constitution, and since that amendment was not an ordinary law, therefore the court could not call it into a question. So do you see the parliament could amend the constitution whatsoever in any way? It could reduce the power of the executive, it could reduce the power of the judiciary, it could do anything and everything. But now, with this, the basic structure doctrine, the supremacy of the legislature was no longer there. Now the supremacy of the judiciary came, because any action of the executive or the legislature would be called into question in the Supreme Court. So therefore, it made the Indian judiciary the most powerful institution in the world. All right, and it brought in an era of judicial supremacy in the name of constitutional supremacy. When the courts declared this, they said that the constitution is supreme. However, do you see that it has led to the institution of supremacy of the judiciary in the name of supremacy of the constitution? All right. Lastly, it is also said, criticized, basic structure doctrine is also criticized on the ground that it is counter-majoritarian. It is counter-majoritarian, which means that when people or the majority, they elect the legislature, right? They elect the legislature and they give the legislature a certain mandate. And on the basis of this mandate, the legislature amends or brings laws, including amending the constitution or the supreme law of the land. However, with this doctrine, it smacks of counter-majoritarian. Even if the majority of the people have voted for a legislature that wants to bring certain changes, the Supreme Court can put its foot down and say, no, we do not agree to this, as it alters the basic structure of the constitution, and therefore we do not agree to such a law. So do you see that it establishes the Supreme Court as a counter-majoritarian entity? All right, and it gives too much power. It gives too much power to an unelected and self-appointed body. All right, we learned earlier that in a democracy, there is a moral argument of separation of powers, that power must be separated and distributed among different entities. However, the people must wield the ultimate power, and people wield the ultimate power. But do you see that it gives too much power to Supreme Court? And the Supreme Court is not an elected body. The Supreme Court is a self-appointed body. It is not an elected body. Therefore, its accountability cannot be called into question by the people. So therefore, a former finance minister had very famously said that the Supreme Court judgments often lead to, when it interferes into the working of other organs such as the legislature or the executive, they say that it leads to the tyranny of the unelected. It leads to the problem of tyranny of the unelected. People have voted for certain models of development, certain laws. They have elected their representatives and sent to the parliament. But when these legislatures, on the behalf of the people who have voted for them, try to make those changes, who interferes and who overrules? The Supreme Court. The people have elected the representatives. The parliament is the elected body. It should be supreme. But now above that, after the parliament's ruling, what do you have? You have the Supreme Court. All right, which is an unelected body whose accountability cannot be questioned by the people, who are not accountable to the people. All right, the Supreme Court is not a body accountable to the people. It is not elected by the people. All right, so do you see that it leads to the tyranny of the unelected? So this is all for this concept class. Thank you so much. We will have a separate class on the judgments. We'll get into individual judgments and you will better understand this. All right. Thank you so much.